paragraph 4. If you just number the paragraph yourself, it starts with, still I was aware this poster boy for the Paralympic Games could have flashes of a darker side. I experienced this anger shortly before the Beijing Paralympic Games. Oscar was at the pre-games training camp and phoned Mr. O'Sullivan, raging about what he perceived to be inadequate training kit. His fury at the South African management caught me by surprise. Oscar knew he couldn't be ignored, and his anger would ensure his demands were met. I hadn't expected Oscar to be a prima donna. Do you know anything about the accused unhappiness about this?
I was aware of the training kit being insufficient that was supplied to the Paralympic team at that stage.
And he was upset about it.
And that Mr. Pistorius was upset about it.
And so what did he do? You knew that he was upset.
I knew that he was upset.
So what happened?
But as far as I can recall, I wasn't at Beijing at the Paralympic Games. I also wasn't at the training camp. And just to clarify that once an athlete is part of Team South Africa, whether it be to a training camp or during a competition like the Olympics, Paralympics or Commonwealth Games, Team South Africa takes preference and they take over these athletes. Then to any of my athletes.
If he asked you to arrange a ticket for Samantha Taylor, you would have remembered. This must then be a lie that he wrote.
I cannot say if it's a lie that he wrote, because as I said, I cannot recall having to source or secure a ticket for Ms. Taylor to the Olympics.
Okay, let us just take one question at a time. If he asked you, you would have remembered.
Probably. I cannot recall.
Okay. Then, you just go to the next paragraph. I don't even feel like going to London now that you won't be there with me. I don't know how I let it go this far, but I'll never forgive myself for not looking after your heart that you place in my hands. So he's referring to, if he says, I don't feel like going to London, what is he referring to?
He must be referring to the London, either Olympic Games or Paralympic Games.
Yes. So, still you're saying that you never knew that he wanted her to go?
As I stated, as far as I can recall, I cannot recall that I was specifically asked to find or source or secure a ticket for Ms. Taylor.
I would just, for completeness sake, my lady, read at page 29 the evaluation, just to put that before the court. That's page 29 of the psychologist's report. It's a report that was commissioned by you, requested by you by Professor J.G. Scholz, dated 27 June. Mr. Pistorius is being treated and should continue to receive clinical care by a psychiatrist and a clinical psychologist for his current condition. Should he not receive proper clinical care, his condition is likely to worsen and increase the risk for suicide, and in a reference to references. No evidence could be found to indicate that Mr. Pistorius has the history of abnormal aggression or explosive violence. Abnormal aggression and violence was never incorporated into his personality, as borne out by both psychometric testing and collateral information. He does not display the personality characteristics of narcissism and or psychopathy that are mostly associated with men in abusive relationships and have been linked to rage-type murders in intimate relationships. Those who know him describe him as gentle, respectful, and conflict avoidant. The times when he did become angry were found to be suitable for the situation and context. His style of conflict resolution is to talk through the situation or remove himself from the situation. He also has the ability to self-reflect afterwards, mostly leading to feelings of guilt and an apology from him. His ability to regulate his effect is well developed. There is evidence to indicate that Mr. Pistorius does have a history of feeling insecure and vulnerable, especially when he's without his prosthesis. He has also been exposed to crime directly and indirectly throughout his life. A reaction to a threatening situation comprises more than flight or fight. An appraisal takes place instantly, whereby the individual assesses firstly the intensity of the threat and then his position to cope with the threat. These appraisals are influenced by, amongst other things, previous experience.
psychiatric diagnosis at the time of the alleged offence according to DSM-5? None. Currently, the accused presents with an adjustment disorder with mixed anxiety and depressed mood that developed after the alleged incident. This has no bearing on paragraph C. Paragraph C reads, at the time of the alleged offences, the accused did not suffer from a mental disorder or a mental defect that affected his ability to distinguish between the rightful and wrongful nature of his deeds. A mental disorder or mental defect did not affect his ability to act in accordance with the said appreciation of the rightful or wrongful nature of his deeds.
Would you kindly read the contents of paragraph 23?
With reference to paragraph 23, I have also found Mr. Pistorius to be hypervigilant. I have observed this behavior, particularly with him rapidly looking around a room and scanning when we are in the dining hall setting, the team setting, and even during one-on-one consultations in my rooms. With reference to paragraph 24, he presents with a very exaggerated startle response, which I have observed a number of times at opening or closing ceremonies when the events were marked by fireworks. Whilst I have seen this exaggerated response in a number of the Paralympic athletes, Mr. Pistorius exhibits an excessive response which involves him covering his head and ears and cowering away until the noise ends.
Professor, whilst you've testified that you have indeed communicated with the two persons who forwarded these communications to you, might I inquire from you whether, with particular reference to Mrs. Kent, you've had any personal interaction with her, in the sense that you've perhaps met her in person?
Well, besides the meeting with Mrs. Kent in London, I have met with her at the Sports Science Institute in Cape Town, and I've had numerous Skype conversations with Mrs. Kent.
Would you then, for contextual purposes, read out paragraph 30?
Now I'm sitting thinking, how would the court listen to an email sent by a person in London to our expert witness, giving him advice about her life and about conclusions she's drawn? That is just hearsay. I know that the hearsay is admissible when an expert witness gives evidence, but this is just going too far. I just don't see how this is relevant.
I think such an exercise would be fruitless. I am not even going to entertain it for the reasons that I have already said. The evidence is not relevant. Counsel for the state correctly argued that the purpose for which the evidence is tendered is strange. I agree. One cannot use the evidence to support and supplement the report and still claim that the emails are not used to establish the truth of the contents. For the above reasons, the objection by counsel for the state is sustained. My finding is that the two emails from pages 27 to 30 by Professor DERMAN of Professor DERMAN's report are hearsay evidence and irrelevant. They are therefore not admissible. In addition, I order that the portion of the email on page 27, which has already been read into the record, be expunged from the record.
I'm instructed to raise a particular aspect concerning the exhibits marked PPP and QQQ. It is a request that we will ask your ladyship to consider with reference to, and we've learned that consent has been granted for these two reports to be released into the public domain. My lady, I'm alive to the fact that we have dealt with the conclusions on the record. It is what it is. It is out there. However, as for the balance of what is contained in those reports, particularly the report of Professor Scholz, a lot of very personal and intimate information is contained in those reports.
I grant an order prohibiting publication of the contents of these exhibits apart from the findings that were put on record. I'm aware that especially QQQ is already out there in the public. I would specifically ask the media people to be careful. If, as from this moment, there is publication, that will be contempt of court.